The letter was taped to my front door at 7:12 on a Tuesday morning. Not mailed. Not emailed. Taped. It had the Crestwood Hills Homeowners Association logo at the top, a signature from the architectural committee at the bottom, and one sentence in the middle that made my stomach drop before I'd even finished my coffee. Your rooftop solar array must be removed within 30 days. 18 panels. $31,600. And 30 days to tear them off my own home because, according to the HOA, they materially disrupted the Mediterranean roofline aesthetic of the community. I stood there in my driveway in Riverside, California, holding that letter while the sun was already hitting those panels hard enough to make the inverter hum inside the garage. It was July. Our electric bill the previous summer had climbed to nearly $600 in 1 month because of the air conditioning. My wife, Elena, worked from home. I worked maintenance for the school district. We had 2 kids, a 12-year-old daughter named Sophia and a 9-year-old son named Mateo. We weren't trying to make some statement. We were trying to stop paying what felt like a second mortgage to keep the house cool. And the HOA wanted the whole system gone. Not moved. Not modified. Removed. The worst part was that we had asked for approval before we installed anything. We had sent plans, renderings, panel measurements, photos of the roof from the street, the contractor's license, the warranty paperwork, everything. The architectural committee had taken 34 days to answer us. Then, when they finally did, they sent a vague response saying our application was under review. Our installer told us that our city permit was already approved. The financing deadline was approaching, and the state program we qualified for would expire if we delayed too long. So I emailed the HOA again. I called twice. I left a voicemail. Nothing. Then, almost 6 weeks after we submitted the application, the HOA sent a letter saying the project was approved, subject to standard architectural compliance. So we installed the panels 3 months later, after they had been sitting there in plain sight. After the association manager drove past our house twice a week. After our neighbors had asked us for our installer's number, the board suddenly decided our solar panels were a violation. I thought I was dealing with a petty rule. I didn't yet understand I was dealing with a board president who had been using the HOA's rules to protect one thing above everything else: her own property value. And when Anna found the meeting minutes, they thought nobody would ever look at. The problem stopped being 18 panels on my roof. It became proof that the people running our HOA had one set of rules for themselves and another for everybody else. I've lived in Crestwood Hills for 8 years. It's one of those riverside neighborhoods built in the early 2000s. All stucco homes, red tile roofs, drought-tolerant front yards, and streets with names that sound like they came from a brochure. Juniper Crest, Valencia Ridge, Sierra Cour. When we bought our house, I didn't love the HOA part. Nobody does. But the dues were manageable. The neighborhood was clean. And the schools were close. At the time, I thought the rules were mostly about keeping people from parking broken RVs on their lawns or painting their homes neon green. I could live with that. The trouble started slowly, the way most HOA trouble does. A warning letter to a neighbor because his trash can sat beside his garage for an extra day. A fine for a woman down the street because her patio umbrella was not an approved earth tone color. A retired couple on our block being told their new front door was too dark. Even though it was almost identical to the old one, people complained, but nobody pushed back very hard. The board had a reputation for wearing people down. You'd get a notice, then a fine, then another notice with more legal language. And eventually, most homeowners would just pay it or change whatever the board wanted changed. The board president was a woman named Linda Hargrove. Linda was in her late 50s, always perfectly dressed, always carrying a leather binder, always speaking in that polished tone people use when they want an unreasonable thing to sound like common sense. She'd say things like, "We all have to make small sacrifices to preserve the character of the community." What she meant was, do what the board says. Linda lived 3 houses down from us. on the corner lot with the biggest front yard. Her house had been featured in the neighborhood newsletter twice. She had a Spanish-style fountain, imported-looking tile around her entryway, and landscaping that probably cost more than my first car. She also happened to be one of the people who could see the upper edge of our roof from her upstairs bedroom window. At first, I didn't connect that fact to anything. I should have. The solar project started because our utility bill got ridiculous. We had done everything people tell you to do. We replaced the old windows, installed a smart thermostat, added insulation in the attic, changed out the pool pump. We even stopped using the dryer as much during peak hours. But every summer, the bills still jumped. Then Elena's mother moved in with us after a health scare. We needed to keep the house cool during the day. We couldn't play the game of turning the air conditioning up to 81 and hoping nobody got sick. So we met with 3 solar companies. The first one gave us a quote that looked too good to be true, which usually means it is. The second one tried to sell us a battery system we couldn't afford. The third company, Inland Sunworks, was run by a guy named Marcus Bell. He was straightforward. He measured the roof, showed us the production estimate, explained the financing, and told us exactly what would happen with permits and HOA approval. He didn't promise miracles. He said, "You're not going to get rich from solar. You're going to stop getting punished every time the temperature hits 108. That sounded honest. The plan was 18 black panels on the rear-facing and side-facing roof planes. They would be low profile. No giant frames. No bright silver brackets. From directly across the street, you could barely see them. The installer had even designed the layout to avoid the front roof line as much as possible. The total cost was $31. $600 before incentives. It was a huge amount of money for us. We financed part of it, used savings for the rest, and spent weeks going over numbers at the kitchen table. Elena worried we were taking on too much. I worried we'd wait another year and get hit with another summer of crushing bills. Finally, we agreed. We submitted our HOA application in February. The CC&Rs required homeowners to submit exterior changes to the Architectural Review Committee. Fair enough. We filled out every form. We included the contractor's site plan and the city permit application. We gave them digital copies and paper copies. Then we waited. 2 weeks passed. Nothing. 3 weeks. Nothing. By the 4th week, Marcus called and said our permit window was moving faster than expected. The city had reviewed the plans, and the financing company needed a projected install date. I emailed the HOA manager, Dana Price, and asked for an update. She replied 2 days later with a short sentence. Your application remains under review by the committee. No explanation. No questions. No request for changes. Just under review. I asked if the committee needed more information. No response. I called. No response. Elena called. No response. Then, on day 34, we received a letter from the Architectural Committee. It said our solar installation had been approved subject to standard compliance with all governing documents, municipal permits, and visual integration requirements. I read it 3 times. There were no special conditions, no demand to relocate panels, no request for a different design, no warning that the approval was temporary. Nothing. So we signed the final contract. The installation took 2 days. I remember standing in the backyard with Mateo while the crew carried panels up a ladder. He kept asking if our house would make electricity from the sun now. Sophia took pictures and sent them to her friends. Elena made lemonade for the crew because it was already 94 degrees by noon. When the system came online, I opened the app on my phone and watched the production number climb. It wasn't dramatic. It was just a line on a screen. But it felt like relief. The first month, our bill dropped by more than half. The second month, it dropped again. By June, when other people on our street were complaining about summer rates, we were finally breathing. Then Linda Hargrove stopped her golf cart in front of our house. She did it on a Saturday morning. I was trimming the hedges, Elena was inside helping her mother with breakfast. Linda rolled up slowly, sunglasses on, clipboard sitting in the passenger seat beside her. She looked at the roof for a long time. Then she said, "You installed more panels than I expected." I set the trimmer down. We installed the plans that were approved. She nodded like she had heard me, but didn't accept the answer. "I can see the array from Valencia Ridge," she said. "It changes the roofline. It's on the side and rear planes." I told her. "Most of it isn't visible from the street." "That depends on the street." I remember wiping my hands on my jeans. "Was there a problem with the approval?" Linda smiled, but not warmly. "The board is reviewing some concerns." "What concerns?" "The community is very particular about its aesthetic identity." I looked at her. "Our solar panels are black. They sit flat on the tile. The city approved them. The HOA approved them." She gave a small shrug. "Approvals can be revisited when circumstances require it." Then she drove away. At the time, I thought she was just being Linda. A few days later, the violation letter showed up on our door. The letter accused us of installing an unapproved and visually disruptive roof alteration. It gave us 30 days to remove the system or face daily fines of $100, legal action, and a lien against the property if the fines remained unpaid. I read it in the kitchen while Elena stood across from me, both hands flat on the counter. "Tell me they can't actually do that," she said. I wanted to tell her no. I wanted to tell her it was a mistake. That one phone call would fix it. But I had no idea. I called Dana, the property manager. She told me the board had reconsidered the approval after receiving complaints from homeowners. "How can they reconsider an approval after the system is installed?" I asked. "The committee retains discretion," she said. "Based on what?" "Based on community standards." "Who complained?" "I can't disclose that." "Can you disclose whether the person who complained is on the board?" There was a pause. Then she said, "I can't discuss internal board communications." That was when I knew this wasn't normal. I asked for a hearing. Under the association rules, homeowners could request a hearing before fines were imposed. I sent the request by certified mail and email. I included the approval letter, the installation plans, the city permit, and photos showing the panels from the street. The hearing was scheduled for the following Thursday. Anna Reyes came into the story because she was Elena's cousin. Anna wasn't a lawyer. She made that clear every time anyone asked. She worked as a project coordinator for a construction consulting firm in Orange County. And before that, she had spent years helping property owners organize permit records, contractor files, and city documents. She had a strange talent for reading boring paperwork until the important part revealed itself. When Elena called her and told her what happened, Anna said, "Send me every piece of paper, even the emails you think don't matter." I emailed her everything. The application, the approval letter, the violation notice, the CC&Rs, the architectural guidelines, the contractor plans, the city permit, the emails with Dana, the financing agreement, even the photos Mateo took during the installation. Anna called me that night. Her first question was simple. "Did the HOA ever tell you, before installation, that solar panels were prohibited?" "No." "Did they ever tell you there was a required placement plan?" "No." "Did they ever ask you to reduce the number of panels?" "No." "Did they ever deny the application?" "No." "They approved it." She was quiet for a moment. Then she said, "Okay, don't remove anything. Don't argue with Linda in person. And don't miss the hearing." I asked, "Can they really fine us?" Anna said, "They can send letters. Whether they can enforce what they're threatening is a different question." That hearing took place in the clubhouse conference room, which was built to host birthday parties and book clubs, not disputes about $30,000 solar systems. There were 6 folding chairs on one side of a long table. Linda sat in the middle, with 2 other board members beside her. Donna, the manager, sat at the end with a laptop. I sat across from them with Elena. Anna came with us, carrying a thin blue folder and a legal pad. Linda opened the meeting by saying, This is an informal compliance hearing. We're here to determine a path forward that preserves the integrity of Crestwood Hills. That was Linda's favorite kind of sentence. It sounded neutral until you realized it always meant someone else was about to lose. I handed them the approval letter. Linda barely looked at it. We acknowledge that an initial administrative response was issued, she said. An initial administrative response? I asked. It says approved. The committee's approval was contingent on compliance with all aesthetic standards. Which standard did we violate? She slid a printed photograph across the table. It was taken from somewhere near the corner of Valencia Ridge. You could see the upper portion of our roof above a line of trees. The panel array presents an industrial appearance inconsistent with the community's Mediterranean character. I looked at the photo. You could see maybe 5 inches of black panel surface. This is what you want us to spend another $30,000 removing? I asked. Linda leaned back. We are not responsible for the financial decisions you made before ensuring final compliance. Elena's face changed when she heard that. She had been holding herself together until then. I could tell she wanted to say something, but she stayed quiet. I said, we did ensure compliance. We applied. You approved it. Linda looked toward Anna. And you are? Anna rages. Anna said, I'm here as family support and to help them keep the documents straight. Linda's smile tightened. Well, Ms. Rages, this is an internal association matter. Anna nodded. That's true. And the approval letter is an internal association document. It's also very clear. Linda folded her hands. The board has discretion to correct approvals made in error. Then show us the error, Anna said. The room went quiet. Dana started typing something. One of the other board members, a man named Stephen Kroll, cleared his throat and said, the concern is visibility. Anna turned to him. Can you point to the section of the architectural guidelines that prohibits low-profile solar panels on a side-facing roof plane? Stephen looked down at his copy of the rules. I don't have the exact section in front of me. Anna said, neither do we, because we couldn't find one. Linda's tone sharpened. This is not a courtroom. No, Anna replied, but it is a meeting where you are threatening a family with $100 daily fine unless they spend tens of thousands of dollars undoing something you approved. I remember thinking that was the first honest sentence spoken in that room. Linda told us the board would deliberate and send a decision within 10 days. On the way out, she stopped me near the door. She spoke quietly so the others couldn't hear. You should think about the long-term value of your home, she said. I looked at her. That's what we were doing. She glanced toward our driveway. Not everyone wants to live next to a roof that looks commercial. Then she walked back into the conference room. That was the moment I started wondering if this had anything to do with our roof at all. 10 days later, the board sent its decision. Violation upheld. 30 days to remove the solar array. Daily fines of $100, beginning on day 31. And an additional statement saying that if we refused, the association could pursue all remedies available under the governing documents. Elena cried when she read it, not because she thought Linda was right, because it felt like we had done everything the right way and still somehow ended up trapped. We had followed the process. We had paid for permits. We had hired a licensed contractor. We had submitted the plans. We had received written approval. And now the same people who approved us were telling us to tear it all apart. For 2 days, I did what a lot of people do when they get bullied by an HOA. I went online. That was a mistake. I found message boards full of angry stories. Bad advice. People telling homeowners to stop paying dues, cover their cameras, park junk cars in protest, sue everyone, call the news, make viral videos, shame board members online. None of it helped. Most of it would have made things worse. Then Anna called and told me to come by her apartment after work. Her dining table was covered with papers, not just our papers, printouts from the California Civil Code, pages from the association's recorded CC&Rs, a copy of the state's solar rights provisions, articles explaining homeowners association restrictions, a spreadsheet with dates, emails, notices, and board actions. Anna had highlighted 3 phrases in yellow. She pointed to the first one. California doesn't let an HOA just ban solar because it doesn't match somebody's favorite roofline, she said. I sat down. She explained that California had long protected homeowners' ability to install solar energy systems. Associations could impose reasonable restrictions in some circumstances, but they could not make solar systems effectively impossible, significantly reduce their performance, or impose unreasonable costs just because a board preferred a certain look. She wasn't giving me legal advice. She said that over and over, but she had done enough homework to show me that Linda's letter was not the final word. Read this part, Anna said. The law did not mean an HOA had zero authority. They could require a particular location if it was reasonable. They could ask for a clean installation. They could review plans. But restrictions that added too much cost or reduced efficiency beyond limited thresholds could be invalid. Anna tapped our production report. Your installer designed this layout because the back roof and side roof get the best sun. If they force you to move the panels to the least visible location, what happens? They produce less power, I said. But how much? I don't know. Then we asked the installer. The next day, Marcus came back out to the house. He brought a shade analysis report, the original design proposal, the production estimate, and 2 alternative layouts. The first alternative moved the panels farther back, behind the front ridgeline as much as possible. It looked slightly less visible from the street. It also reduced the estimated annual production by almost 18%. The second alternative used fewer panels in a more hidden arrangement. That one reduced production by more than 24% and required additional mounting work that would cost nearly $9,000. Marcus looked at the HOA letter and shook his head. Nothing about this system is unusual, he said. I've installed dozens in HOAs. Some make you use black frames. Some want the conduit hidden. Fine. But remove the system entirely? That's not about design. He gave us a signed letter explaining the numbers. Anna added it to the blue folder. Then she started looking at the HOA's own records. That turned out to be harder. California law required associations to make certain records available to homeowners upon proper request. Anna helped me draft a polite written request for architectural committee materials related to solar installations, board meeting minutes where solar standards were discussed, and policies governing solar panel approvals. We weren't asking for private homeowner information. We weren't demanding people's emails. We were asking for the records that showed how the association applied its rules. Dana replied that the request was overbroad. Anna revised it. We asked for a narrower set. Dana said some records were confidential. Anna asked which specific records and why. Then, 3 weeks later, a thick packet arrived. At first, it looked useless. Meeting minutes, committee agendas, architecture applications with names redacted, budget reports, a few pages of email summaries, but Anna read every line. She found the first problem on page 68. It was a solar approval from the year before. The applicant's name was blacked out, but the description was not 22-panel photovoltaic system. Anna read aloud, low-profile black panels, installation on rear and west-facing roof planes. That sounded familiar. The application had been approved without any conditions beyond standard permit compliance. Anna compared the site plan to a neighborhood map. The house was on Sierra Court. Linda Hargrove lived on Sierra Court. At first, I thought it might be a coincidence. There were several houses on that street. Then Anna found a board meeting summary from 4 months earlier. It mentioned that a board member's personal residence has obtained preliminary architectural approval for solar modernization consistent with California statutory requirements. The name was redacted, but the meeting date matched the approval date for the 22-panel project. Anna leaned back in her chair. "Do you know if Linda has solar?" she asked. I didn't. The next Saturday, I drove past Linda's house slowly on my way to the grocery store. Her roof had been designed with more angles than ours. From the street, you couldn't see much. But from a side street, at the right angle, I saw them. Black solar panels, 22 of them. Not on the back alone. on the west-facing roof plane, exactly like the redacted approval described. The panels were more visible than ours. I parked 2 blocks away and took a picture from the public street. Then I took another, and another. I didn't trespass. I didn't point a camera into her windows. I just documented what anyone driving by could see. When I got home, Anna pulled up the county property map. Linda's house was the only home on that part of Sierra Court, with a west-facing roof plane configured that way. The redacted application belonged to her. That was bad enough. But the real problem came from an email summary buried in the packet. It referred to an architectural committee discussion 2 months before our violation notice. The summary said the committee had received multiple concerns regarding highly visible rooftop solar installations in proximity to premium view corridors. One board member had suggested updating the guidelines. Another had warned that any new rule had to be consistent with state protections for solar. Then there was a note attributed to the board president. Visibility concerns should be addressed promptly before the trend becomes widespread. Anna read it twice. Before the trend becomes widespread, she said. I knew what that meant. Linda had installed solar on her own house when it benefited her. Then, after she got hers approved, she wanted to stop other people from doing the same thing if she thought it might affect the view from her property or change the look of the street around her. Our house was the first one directly below her sightline. She didn't care about Mediterranean rooflines. She cared about looking out her upstairs window and seeing something she didn't approve of. For a few minutes, I was furious. Not loud furious. The kind that makes your hands feel cold. We had spent money we didn't really have because we were trying to do something responsible. We had relied on a written approval. We had followed every rule we knew about. And the person trying to force us to tear everything down had a larger solar system on her own roof. I wanted to confront Linda right then. Anna stopped me. No, she said. Not yet. Why not? Because right now, she can call you emotional. She can say you're upset because you got a violation. We need to make this about the records. What records? The approval, the law, the production loss, the selective enforcement, and the fact that they ignored their own process. That was when Anna started building the timeline. Not a rant. Not a dramatic speech. A timeline. February 3, we submitted our application. March 8, the Architectural Committee approved the project. March 20, city permit issued. April 6 and April 7, installation completed. April through June, no OA notice. No request for correction. No objection. June 18, Linda raised visibility concerns in a board discussion. June 25, a solar-related guideline revision was discussed but never formally adopted. July 2, the HOA served us with a violation notice demanding full removal. July 19, the board upheld the violation despite its earlier written approval. Then Anna added another section. May 11 of the previous year, Linda's 22-panel application approved. May 15, committee meeting noted statutory solar protections. June 2, Linda's system installed. No violation. No reconsideration. No warning that her roofline was industrial. No 30-day demand to remove anything. Anna said, "This is the part where you stop arguing about whether the panels are pretty. What do we argue about? Whether the HOA can punish one homeowner for doing what it allowed a board president to do." We met with an attorney named Rachel Vaughn. She practiced community association and real estate law in Riverside. Her office wasn't fancy. It was above a tax preparation business in a small commercial building, but Rachel listened closely, asked sharp questions, and didn't make promises she couldn't keep. She read the approval letter. She read the violation notice. She read Marcus's production analysis. Then she looked at the records Anna had organized. "This is not a slam dunk because HOA disputes rarely are," she said, "but the board has problems." "What kind of problems?" I asked. "First, written approval, followed by retroactive punishment. Second, a restriction that appears to require removal of a legally installed solar system. Third, possible unreasonable limitations under California solar protections. Fourth, inconsistent forcément. Elena asked, "Can they make us remove it?" Rachel looked at her carefully. "They can try, but based on what I'm seeing, I would not voluntarily remove anything." That was the first time in weeks I felt my shoulders relax. Rachel sent the HOA a formal letter. It was not angry. That surprised me. It was calm. It laid out the facts. It attached our original application, the approval letter, the city permit, Marcus's analysis showing the cost and production loss of the HOA's demanded alternatives, and references to the applicable California protections for solar energy systems. It asked the association to withdraw the violation, suspend fines, preserve all records related to solar approvals and architectural enforcement, and confirm that no lien action would be taken. It also said that if the association refused, we were prepared to pursue available remedies, including recovery of attorney fees where permitted. Linda's response arrived through the HOA's lawyers 6 days later. They did not withdraw the violation. Instead, they claimed the original approval was administrative in nature and did not waive the board's power to enforce community standards. They said the board was not banning solar generally. They were merely requiring us to remove an excessively visible configuration and resubmit a new design. They also said comparisons to other homes were irrelevant because architectural decisions are made on a case-by-case basis. Rachel read the letter and said, "They're trying to make this sound more reasonable than it is." "What do we do?" I asked. She said, "We give them one more chance." I hated that answer. Not because it was wrong, because I wanted them to feel what they had put us through. But Rachel explained that a clean record mattered. If we could show that we tried to resolve the matter fairly and the board kept refusing, it would strengthen our position. So we attended another hearing. This time, Rachel came with us. The room was fuller. 2 homeowners had heard about our case and asked to observe. The HOA allowed them to sit quietly in the back. Linda sat at the same spot in the middle of the table, but she looked different that night. Less relaxed. Maybe she knew we had seen the records. Rachel began by placing a binder in front of every board member. "Before we discuss remedies," she said, "I want the board to understand the factual record." Linda interrupted. "This meeting is not intended to be adversarial." Rachel didn't even look up. "It became adversarial when your association threatened to fine my clients $100 per day unless they removed a system you approved." Then she walked them through the timeline. The approval, the permit, the installation, the delay, the violation, the demanded removal, Marcus's report, the estimated loss in energy production, the cost of redesign, the California rules limiting unreasonable restrictions. Then she opened the section about selective approval. Linda's face stayed still until Rachel placed the photo of Linda's roof on the table. The room went silent. Rachel said, "The association has treated my client's low-profile 18-panel system as a prohibited visual disruption, yet the board president's 22-panel system, installed under substantially similar circumstances, was approved without objection." Linda's voice was tight. "My home is positioned differently." Rachel nodded. "It is, in a way that makes the panels more visible from a public street." Stephen Kroll looked at Linda. The other board member, Carla Monroe, stared at the documents in front of her. Linda said, "This is a personal attack." I finally spoke. "No, it's the same rule you used against us." She looked at me. For the first time since this started, she didn't have a quick answer. Then she said something I will never forget. "You're turning a simple design dispute into a political issue because you don't like being told no." I looked at the approval letter in front of her. Then I said, "You didn't tell us no. You told us yes. You waited until we paid $31,600, and then you tried to change the answer." Rachel asked the board to vote that night to suspend the violation and fines while the matter was reviewed by independent counsel. Linda refused. She said the board needed more time. Rachel asked how much time. Linda said, "As long as necessary to protect the association." That sentence did more damage to her than she realized, because from that point on, the case stopped being about whether our panels matched the roof tiles. It became about whether an HOA president could use as long as necessary to force a family into financial panic after the association had already given approval. Rachel filed for dispute resolution and sent a demand for the association's full solar approval history. The HOA had to respond. That was where things started to unravel. The records showed that over the previous 4 years, Crestwood Hills had approved 11 solar installations. 9 of them were approved with standard conditions. 1 had been asked to change conduit placement, and ours was the only one that had been ordered removed after installation. The records also showed something else. Linda had pushed for a new solar visibility policy, but the policy had never been properly adopted. There was no vote, no notice to homeowners, no updated architectural guideline distributed to the community. There were only discussions, draft language, and Linda's repeated complaints that solar panels were becoming too common in sightlines near higher-value homes. One email was especially damaging. It came from Linda to Dana, the HOA manager, 2 weeks before we received our violation notice. The email said that if our panels remained in place, other homeowners will assume they can fill every visible roof plane with equipment. Dana had replied, "We should be careful because state law restricts solar limitations." Linda responded, "Then make this about the approval defect, not solar itself." That was it. That was the sentence. Not a misunderstanding. Not a good faith design disagreement. A plan to dress up a personal objection as an administrative defect. Rachel told us not to celebrate yet. She said emails were powerful, but cases still took time. The HOA could deny, delay, or try to settle quietly without admitting anything. But the board members had started asking questions. Carla Monroe called a special executive session without Linda's support. Stephen Kroll asked the association lawyer whether the board had exposure for selective enforcement. Homeowners began requesting their own solar records. A couple on Juniper Crest learned their application had been quietly delayed for months. Another family discovered the committee had told them panels should be placed only on their least efficient roof plane, even though no written policy required it. People got angry, not because everyone suddenly loved solar panels. Some homeowners didn't. A few said they still thought the panels looked bad. But almost everyone understood the bigger issue. If the board could approve something for itself, then punish another homeowner for the same thing, nobody's approval meant anything. At the next monthly board meeting, the clubhouse was packed. Usually, those meetings had maybe 7 people. That night, more than 60 homeowners showed up. Some stood along the walls. Others sat in folding chairs in the hallway because there wasn't enough room inside. Linda looked furious. She opened the meeting by saying public comments would be limited to 3 minutes per person. The first speaker was a man named Harold Bennett, who had lived in Crestwood Hills since the first homes were built. Harold was retired military. He was not a dramatic person. He had never spoken at a board meeting before. He walked to the microphone holding a copy of the solar approval records. Then he said, "I don't care if you like solar panels. I care that you approved the president's panels and tried to fine another family into removing theirs. That's not architecture. That's favoritism." The room erupted. Linda tried to call for order. Then a woman named Priya Shah stood up. Her family had been thinking about solar for 2 years. She said, "We delayed our project because we were told the board might not approve it. Now I learned the board president already had hers approved. How are we supposed to trust this process?" Then another homeowner said Linda had threatened him with fines over a backyard shed, even though the shed had been there before Linda became president. Then another. It was like someone had opened a valve. Every small grievance people had kept, private started coming out. Linda tried to defend herself. She said she had always acted in the best interest of the community. She said homeowners were misunderstanding the complexity of architectural review. She said she never personally instructed anyone to target our family. But Rachel had already sent the email to the association's lawyer. The lawyer was sitting in the back of the room that night. He did not speak. He did not need to. 3 days after that meeting, The HOA's attorney contacted Rachel. The board wanted to resolve the dispute. The terms took another 2 weeks to negotiate. The association agreed to withdraw the violation notice completely. They agreed to cancel all threatened fines. They agreed that our solar system would remain in place without modification. They agreed to reimburse a substantial portion of our attorney fees and the independent engineering review we had paid for. They agreed to adopt a written solar policy consistent with California law, including clear timelines for review and a requirement that any requested modification be supported by documented design or safety reasons. They agreed that approvals could not be retroactively revoked without evidence of fraud, material deviation from approved plans, or a genuine safety violation. And they agreed to provide training for board members and the architectural committee. The HOA did not admit wrongdoing in the settlement. They never said, "We were wrong." HOAs rarely say that, but the policy changes said it for them. Linda resigned as board president before the next election. She tried to stay on the board as a director, but she lost that seat too. The vote wasn't close. Carla became interim president. Stephen resigned 2 months later, saying he had relied too heavily on Linda's judgment and should have asked harder questions. Donna, the property manager, stayed. But the board hired a new association attorney and formed an architectural committee with homeowners who had actual experience in construction, energy, and property management. A few months later, Crestwood Hills held a community meeting about solar guidelines. That might sound boring, and honestly, it was. There were spreadsheets. There were diagrams. There was one man who spent 12 minutes asking about conduit colors. But it was also one of the most satisfying nights I have ever had in that neighborhood, because people were talking openly, not whispering in driveways, not worrying about getting targeted, not assuming the board's first answer was final. The new policy allowed homeowners to install solar systems with reasonable aesthetic requirements: black frames, low-profile mounting when feasible, neat conduit routing, clear application timelines. But no blanket ban. No secret standard. No rule that only applied when Linda Hargrove didn't like what she saw from her window. The summer after the settlement, our electric bill in July was $178. That was still money, but it wasn't $592. It wasn't the kind of bill that made Elena and me sit at the kitchen table trying to decide what we could postpone. Sophia started joking that the roof was finally earning its keep. Mateo told his friends our house had sun power. And Elena's mother sat on the patio one afternoon, looked up at the panels, and said, "Funny how something so useful can bother people who don't have to pay your bills." She was right. I never got an apology from Linda. Not a real one. A month after she lost the election, I saw her at the grocery store. We were both standing near the produce section. She looked at me, looked away, then came back a minute later. She said, "I hope you're happy with what happened." I thought about all the things I could have said. I could have reminded her about the letter taped to our door. I could have mentioned the fines. I could have mentioned the email where she told the manager to make it look like an approval problem instead of a solar problem. But I didn't. I just said, "I'm happy my family gets to keep what we were approved to install." She stared at me for a second, then she walked away. That was enough. I didn't need her to admit she had tried to bully us. The records did that. I didn't need to humiliate her. The vote did that, and I didn't need revenge. I needed the rules to apply evenly. That's what Anna understood before I did. When people in power act like a rule belongs to them, the instinct is to fight louder, to match their anger, to turn every conversation into a war. But Anna kept bringing us back to the same things: the approval letter, the dates, the production report, the law, the board minutes, the email. Facts are not always exciting at first, but when someone has been hiding behind vague authority, facts are usually where the real pressure begins. Our 18 panels are still on the roof. Linda's 22 panels are still on hers. And honestly, I'm glad. I don't want her to lose electricity savings just because she tried to take ours away. I just wanted her to live under the same rules. Because a community is not protected by forcing everyone to see the world exactly the way the board president sees it. It's protected when the rules are clear, fair, and strong enough to apply to the people in charge too. If your HOA approved something and later tried to punish you for it, would you have fought it, or would the pressure of daily fines have forced you to give in? Some people will say a neighborhood needs strict standards. Others will say no board should be allowed to rewrite the rules after a homeowner has already spent thousands in good faith. Where do you draw the line between protecting a community's appearance and protecting a homeowner's right to make a practical decision for their family? Leave your take below. I read more of these than you might think. This video is a dramatized storytelling narrative based on real-life themes and HOA regulations. Names, characters, and specific locations have been changed. Visuals are generated using AI tools for illustrative purposes only. This story is not legal advice. Property laws, HOA rules, and local regulations vary. So, consult a qualified professional about your own situation.